Hello and welcome back to my vlog. Outside today. It's not really warm, but it's nice enough. And it's a little later in the day, so it's not as much light as I would have liked, but I'm not going to use any artificial light. So, you know, all you need to do is hear me. Anyway, we're on to part 2 of this 3-parter of Pete Hendrickson's report here about as long as myths about the income tax persist. Adam Smith's definition of capitation, and therefore that of the framers, includes the following among much else. The taxes which, it is intended, should fall indifferently upon every different species of revenue are capitation taxes. Capitation taxes, if it is attempted to proportion them to the fortune or revenue of each contributor, become altogether arbitrary. The state of a man's fortune varies from day to day, and without an inquisition more intolerable than any tax, and renewed at least once every year, can only be guessed at. Capitation taxes, so far as they are levied upon the lower ranks of people, are direct taxes upon the wages of labor, and are attended with all the inconveniences of such taxes. In the capitation which has been levied in France without any interruption since the beginning of the present century, the highest orders of people are rated according to their rank by an invariable tariff, the lower orders of people according to what is supposed to be their fortune by an assessment which varies from year to year. That's from an inquiry into the nature and causes of the wealth of nations by Adam Smith, chapter 4. Bear in mind that Smith is using the common word wages, not the custom-defined legal term of the same spelling found in the modern revenue laws. Smith goes on to discuss the version of capitations imposed under the name of poll taxes as well, observing that in the first poll tax, for instance, many were taxed according to their supposed fortune, being, quote, assessed at 3 shillings in the pound of their supposed income, end quote. Capitations are specifically subject to the apportionment requirement. Quote, no capitation or other direct tax shall be laid unless in proportion to the census or enumeration hereinbefore directed to be taken, end quote. United States Constitution, Article 1, Section 9. This requirement has never changed and remains in force today, the 16th Amendment notwithstanding. In fact, the amendment came about solely in order to undo a ruling in the Pollock case concerning the taxation of dividends and rent. Pollock was a stockholder who argued that the attempt by Congress in 1894 to tax dividends and rents from investments in federally subsidized railroads and real estate as income was unconstitutional because a tax on such gains had to be apportioned. Pollock reasoned that since the dividends and rent were derived from personal property, his stock, the tax on them amounted to a property tax on the stock itself. The court agreed. Congress responded to the Pollock decision 19 years later with the 16th Amendment, which was designed and approved solely to overturn that one nuanced ruling of the court. The amendment has no other effect and, in fact, couldn't. Remember, everything else subject to the tax was taxable without apportionment even before the amendment. In 1916, shortly after its adoption without challenge by the states, despite the fact that many appear to have not ratified the amendment, and the passage of the 1913 Act reviving what had become the dormant income tax, the nature and effect of the 16th Amendment was spelled out by the Supreme Court. In a test case just for that purpose, Frank Brushaber, I'm not sure exactly how to pronounce his name, I've heard it many different ways, Brushaber, I'll just say Brushaber, asserted that the tax on his railroad stock dividends was unconstitutional because it amounted to a direct, unapportioned tax, just as had Pollock 21 years earlier. In response, the Supreme Court carefully explained that the sole effect of the 16th Amendment is to overrule the Pollock Court's finding that the application of the tax to qualified dividends and rent amounted to a property tax, thus invoking the apportionment requirement in such cases. First, the court debunks Brushaber's argument that the amendment created some inherently invalid hybrid tax. Quote, We are of opinion, however, that the confusion is not inherent, but rather arises from the erroneous assumption that the 16th Amendment provides for a hitherto unknown power of taxation, that is, a power to levy an income tax which, although direct, should not be subject to the regulation of apportionment applicable to all other direct taxes. End quote. Brushaver versus Union Pacific Railroad Company, 240 U.S. 1, 1916. The court pointed out that a hybrid tax would cause, quote, ellipsis, one provision of the Constitution to destroy another. That is, it would result in bringing the provisions of the amendment supposedly exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes be apportioned, end quote. Brushaber supra. It was what taxed as income was among the objects of a direct tax, such as a capitation. The irreconcilable conflict described by the court would arise because, as the court makes clear, the capitation clause remains fully in effect. The conflict doesn't arise, but only because what is taxed as income, both before and after the 16th Amendment, is not anything that would qualify the tax as a capitation or other direct tax, whether all that comes in or anything else described by Adam Smith as such. In fact, the Brushaber court goes so far as to declare that if the tax ever should come to be applied to all that comes in, or any other object of a capitation or other direct tax, quote, the duty would arise to disregard form, that is, any pretense by which it is made to appear that the tax is being confined to its proper limits when it is not, such as by creatively construing the meaning of income or the use of any pretense, scheme, or construction by which non-specialized revenue or activities are made to appear otherwise, so as to subject them to the tax. And consider substance alone, that is, what the tax is actually falling upon as a practical reality, and hence subject the tax to the regulation as to apportionment which otherwise, as an excise, would not apply to it. End quote. Brushaber supra. We'll finish tomorrow with part 3, probably some more about Brushaber. I forget. I did read the whole thing, but I didn't read ahead to remember what I was going to read tomorrow. So I hope this is opening your eyes a little bit. I've heard some arguments recently that there were Supreme Court decisions that did lay to rest the argument, and that your normal income that you make on a day-to-day basis is taxable. So anyway, make it a great day, and bye for now.